Intellectual property, proprietary rights, and warranty against infringement. This section of your agreement is the crux of it all. You are giving away your intellectual property or providing limited licenses for use of your intellectual property. Ownership of rights. The ownership of rights clause can go a variety of different ways and is often one of the most disputed clauses in court and in negotiations. There are a few ways to go about it. First of all, you can give up all your IP rights in final work or deliverables. This is standard for a lot of designers, especially for things like branding and logos. Your clients will want all of the IP rights to the final works, considering they might want to trademark it or alter it. It's incredibly important to add into this clause that these rights are only given up upon payment of the full fee, in addition to any expenses and additional services. Also, an important sentence to add is that they will give you an irrevocable, non-exclusive license to use the work within your own marketing. This way you can put it in your portfolio. Secondly, you can keep all of your IP rights and give a limited license to your client. This would be most relevant for coaches and consultants who provide their clients with unique materials. In these cases, you would be giving a limited, non-exclusive, royalty-free license for clients to utilize whatever you produce for them inside of their business. And then add restrictions, such as they cannot resell or share these with others without your permission. Otherwise, the license is revoked and they need to delete any of these pieces of intellectual property off of their servers. Lastly, you can also keep your IP rights and give away another type of non-exclusive, non-transferable, worldwide, royalty-free license to use the work, let's say on their website or in their gallery. This could be for someone who might have commissioned work from you. For example, you are a painter and this work was commissioned. You will be the copyright and IP holder of the painting, but the owner will have it in their gallery. They can resell it, though. Otherwise, you can add a clause where you will be owed royalties on resale. There are so many ways to divide up IP rights. I recently had a client where we created separate IP rights to separate pieces of work that she would create for clients. For example, she would create their branding and logos, which they would get all the IP rights for, but all social media templates that she creates for them, she will provide them with a limited license and keep the IP rights so they cannot sell them in their own services as templates. Next clause is restrictions on use. If you maintain intellectual property rights, you can have a variety of restrictions on the limited license you give your clients, whether they can only use it in their business, only use it on social media, can't resell it, etc. Exclusions. This area is important for designers and programmers as you will most likely want to exclude any working files, drafts, discarded concepts, etc. if you're giving up all of the IP for the final deliverables. Company warranty could include things like you should have a warranty where you state you wouldn't knowingly violate intellectual property rights of any third parties, and have a counter that the client also warrants they wouldn't give you any content that violates any third-party rights. So for example, they can't just copy an image off of Google and give it to you to alter. Additionally, you can add that if client modifies your work in any way, the warranty is void. Client warranty. Make sure there is a clause for client warranties. This could include that client owns a right to anything they provide you to work with, and they conform to ethical and legal standards, that they shall comply with all legal requirements using third-party materials, etc. Trademarks. For those of you making logos out there, make sure there is a clause stating that you are not responsible for checking if the logo that you created can be trademarked, and that this should be a client's responsibility. Let's be real, you're not a lawyer here. Client content. If you are sharing this work on your portfolio, make sure that you have a clause that clearly states any trademarks or anything previously owned by the client is still theirs and you aren't infringing on their rights by putting something on your portfolio. Third-party materials. This is for all of those designers and programmers out there. If you utilize third-party materials like fonts, make sure that you make it clear in your contract that you have warned your client that they are third-party materials and they may need to buy a license for them. And if they use them and don't purchase the license, you are not liable. Release, indemnity, disclaimers, and waiver. This area basically makes sure that you aren't liable for anything, so pay close attention to it. Style release. If you are a designer or a programmer, etc., make sure to have a clause that states your client has looked at your portfolio, knows your style, and cannot terminate a contract because they end up not liking the aesthetic or designs. Now, let's talk about disclaimers. Disclaimers are important for pretty much any industry when it comes to contracts. We discussed disclaimers a little bit in Module 2 and adding them to our websites. You will also need to add specific disclaimers to your contract depending on what kind of service you are providing, such as medical disclaimers, professional disclaimers, no earnings disclaimers, personal decision disclaimers, no guarantees disclaimers, and no warranty. Next up, limitation of liability. Limiting total liability under the agreement to the total amount paid. This should definitely be added to your contract in case anything does happen. You don't want to pay out more than what the contract was worth. Relationship of parties. Relationship. Expressly state the type of relationship between the parties, that it is not an employment or joint venture or partnership. We discussed this a little bit in the beginning about independent contractor versus employee, but also accidentally entering a joint venture or partnership might mean that you could potentially be liable for your client. No exclusivity. This clause states that the client is not restricted from seeking similar services from other providers while engaging with the company, you. And the company, you, is not restricted from offering similar services that are offered to the client. Let's say, for example, you did the branding for soap company number 1. You should be able to do the branding for soap company number 2, even if they compete with soap company number 1. Assignment. This means that the client cannot transfer the agreement to someone else, so pay attention that this clause is included. Imagine if you woke up one morning and your client decided that they could no longer afford the services and decided to sell your contract off to Greg, a friend of theirs. You don't know Greg or his business, but now you have a retainer agreement with them out of nowhere. So make sure you have a clause that prevents this from happening and prevents them assigning your contract to someone else or any other third party. And we have finally reached the general terms in the agreement. You know those terms at the very bottom of an agreement that a lot of people don't read very thoroughly and tend to simply copy and paste over? They're actually really important. So, governing law and jurisdiction. This specifies which laws will apply to the agreement and the jurisdiction where disputes will be resolved. For example, you're located in New York and your client is in Paris. You don't want to get sued under French law and have to go to court in Paris. So make sure this clause is in there. It would not be a fun vacation. Dispute resolution. If dispute arises, this clause governs how it will be handled, whether it is negotiation, mediation, arbitration, or court. In mediation, the disputing parties maintain control, whereas in arbitration, a private judge is in control of the process and outcome. Injunction relief is a court order that prohibits an organization or an individual from taking a specific action. For example, taking down a product that infringes your rights or deleting something, etc. So make sure that this option for relief is in your contract. Force majeure protects parties in the events of an act of God. For example, when the world shuts down because of COVID and you need to terminate your contract, this specific and very special clause will allow you to do so without any consequences. Severability. This is an important clause because if any part of the contract is unenforceable or isn't, let's say, legal in your jurisdiction, it means that the rest of the contract is still valid and still works. So this is an incredibly important clause. I'm looking at you guys that copied and pasted your terms from Google or ChatGPT. Waiver of breach. If you make an exception to a term or clause in this agreement, it does not negate the clause. For example, your agreement states that your client needs to get back to you with revisions in 3 days. If you let your client get back to you in 5 days and there aren't any consequences or anything like that, it doesn't mean that this term is no longer valid. So next time they revise something, their deadline is still 3 days, not 5. Basically, an exception doesn't stop the term from being valid, and you can still use it later on. Entire agreement. No other agreement outside of what is in this contract is valid. So even if you agreed on something via email before you signed the contract, if it's not in the contract, it doesn't matter. Amendments. These basically state how to modify or amend your agreement. Survival. Some aspects of the agreement might survive the end of the agreement. So for example, you finish with the contract, everything's been handed over, all that stuff, and you definitely want your IP rights and confidentiality rights to survive the term of the agreement. So even when the project is over, certain clauses are still valid. This is especially important if you're licensing out intellectual property instead of giving it up. And wow, that's it. Thank you so much for participating in our legal masterclass. Please reach out if you have any questions at all. Our email and social media are below, and I'm always around to help. And also, just so you know, all masterclass students get 20% off Zen Mondays contracts with the code MASTERCLASS20. Have a wonderful day. Thank you so much.